Hello, in today's webinar we're going to cover the steps and process behind your Maritime or Jones Act case. Specifically, what we're going to get into is what happens during your case, when the activities happen, and what it all means to you as an injured maritime worker trying to pursue a Jones Act or maritime case. I'd like to introduce myself. I'm your host today. I'm maritime attorney Tim Young. We have a national practice based out of New Orleans. For more than 23 years, I've been handling maritime and Jones Act cases across the country, specifically focused in the Gulf South, Louisiana, Mississippi, Texas, Alabama, Florida. Many injured workers we've helped with their cases. We've successfully helped clients with brain injuries, major burns, multiple surgeries. We've really been honored and felt fortunate to be able to play an important part in their life, trying to get them back on their feet after they've had a bad accident working offshore on a vessel. We truly enjoy working with our clients. We find the work incredibly meaningful. And today I'm going to talk to you about typically in your Jones Act or maritime case, what you can expect, what it's going to look like once you hire an attorney, and generally how the case progresses after you hire an attorney. This is based on all of my experience and the way we've handled cases, as well as many of my other attorney friends who also handle maritime work. This is generally the way your case is going to progress. First thing to understand is the case is broken down into two main parts. When you get involved in filing a Jones Act or a maritime case, generally you can think of it as two main parts to your case. First part is your medical treatment and establishing your damages. And what this means is you're going to be going to see doctors, you're going to be having tests run to try to determine the nature and extent of your injuries. These tests are going to be very important in helping to establish how you got hurt, what type of injury you suffered, your general damages. This is going to be your pain and suffering. A large amount of this number, of this amount that you're going to be seeking in your case, is going to be related to the doctors and the tests that you're able to bring into court as evidence. Obviously, when you suffer an injury, part of what you have to do when you go to court or when you go to settle the claim is you have to establish the type of injury you suffered. Generally, you're going to need medical tests to do that, to show what type of injury you had, and that all directly relates to your general damages of pain and suffering. Your medical cost and your medical needs are going to have to be addressed here. Again, this is the first main part of your claim. If you think of your claim in two big parts, this is part of that first bucket that we're going through here. Your physical limitations have to be addressed here. So you're going to be going through your pain and suffering damages, you're going to be going through your medical cost and your future medical needs, and you're going to be talking about what type of limitations you have. All of that relates, as you can see there, directly to the doctors and the tests that you have run after your maritime injury. Another part of this first bucket of your claim, this first category of your claim, is establishing your wage loss damages. And this is a part of your damages. Not only do you have your medical physical damages, but you also have your financial money damages. This is your wage loss damage. Generally, it's going to be your loss of income and wages, and it is based on basically what you can earn now in the future compared to what you used to be able to earn in the future before your injury. So, quick example, if you were making $100,000 as a tankerman working on a barge, you have an injury, now you're on land making $20,000 a year, there's an $80,000 difference each year, and experts will come in and calculate the total value of that over your lifetime, and it can add up to a lot of money in some cases. Second part of the claim that you're going to have with the Jones Act case or a maritime case is generally going to be establishing what happened, why, and who's at fault. So again, to kind of give you, and what this amounts to is what percentage of all those damages are owed to you. That's the significance of that second part. Again, to kind of give you a big overview, these are the two main parts of the case. When I meet with potential clients who we may help with their cases, this is how I explain it to them. You generally have a first issue as to how bad is the damage that was caused to you, physical damages as well as financial damages, And then the second part is who's responsible for that damage and why are they responsible. So those are your first and your second parts of your case. If you break it down on real simple terms, that's what it means. Let's go through an overview here. I'm going to kind of move fast through this. This is basically what happens in your case and why. And the first thing, I'll go through each of these in a little bit more detail in a minute, but I'm going to give you a list here. First thing that happens generally is you do the filing of the claim in the court. Next thing that happens is there's what's called interrogatories and request for documents that are propounded. Basically, that's a fancy way to say the lawyers send these back and forth to each other to try to get answers to questions and to try to get requested documents. And this means that you're going to be giving some documents over as well as the company or any defendants in your case. Next part of what happens is generally your deposition, which we'll talk about in a minute. Then you go through witness depositions. These may be your coworkers who witnessed your accident, could be other people. Maybe it's people that worked in the main office in safety and something should have been done differently that they didn't do. So sometimes you'll have to get depositions of people who you actually were not physically with at the time of your injury. Next segment, next part of your case, next stage is generally the experts will get involved at that point because you now have an idea of what happened. You have witness depositions, you have reports, you have materials that you can give to the experts who then go through everything, and they will render their reports and their opinions as to how your injury and your accident could have been avoided, maybe what the company or what the defendants did wrong. One of the next parts of your case is generally the settlement efforts. And you can see here as you kind of go down the list with me, you can see that this is generally a good time to sit down and talk about resolving the damage that was caused to you. What is going to be offered to you? Do you think that's fair or not? At this point, you have a good view of your injuries. You have a good view of what happened. So generally, you can sit down and have your settlement efforts, your settlement talks at this point. Then the last issue here, kind of going through the checklist of what may happen in your case, is ultimately you may have a trial. If you're not able to get the case resolved, typically you're going to move forward. We typically try 1, 2, maybe 3 cases a year for our clients, which may not sound like a lot, but frankly it is, as I'll discuss in a minute. But generally you're going to have a trial if you're not able to get reasonable, fair offers from the defendant or from your company. Now let's go through each of these items in a little bit more detail. This was the first one, filing your claim in court. A lot of times people will tell us they don't know what to do. They don't know how to create that paperwork. We tell them, do not worry. This is basically a few pieces of paper, and the best part is you are not involved generally with it at all. It is a document created by your attorney. It's just a couple of pieces of paper. It's the claim or the petition. They call it a complaint in federal court. It's basically the start of this is what happened to me. It's usually very general terms too. You don't have to have names that are named in it. You generally don't put a lot of details. It's basically just giving the other side notice that you are going to take an action against them and that you're filing a claim in court against them. And we prepare all these for our clients, and our clients generally just give us the background information that we base the suit upon. So this starts the court process. The last item here is what happens now is generally the court process is started, and this becomes real important, as I'll mention in a few minutes. We'll discuss that in more detail as we move through. But the first thing is the complaint, generally 5 to 10 pages, maybe 15 pages in some longer cases with multiple parties. You do not have to draft any of that yourself. You're not expected to know how to do any of that, and this starts the court process for you. This last part here, nothing in the case really happens for about another 60 days. Certainly for about 30 days, maybe as much as 45 or 60 days. The reason for this is what happens once the paperwork is filed in court is the company and the defendants are getting served with it. And then they get served with it, and what they do is they turn it generally over to their insurance companies, and then those insurance companies in turn will call up or phone a local attorney that they then hire to represent them in the case. So there's 2 or 3 steps that are going on behind the scenes here that you don't really see after you file your claim in court. And that is the paperwork gets passed to the insurance company. Those companies then hire their own attorneys, and they stand in the shoes of the company, generally, and they come into court and they say, okay, we're going to go ahead and defend this on behalf of the company. And they're allowed usually about 60 days to file their answer in court. And if they need more time, they can sometimes ask for it. Some judges will give it, some won't. Second part here of the case, after the paperwork is filed in court and the answers are filed, are the interrogatories and requests for documents. This is, again, like I said earlier, a fancy word basically on how to say questions on paper. You get to write down some questions. What's your name? Who are you? Where are you from? How old are you? Give us your background on where you've worked. What kind of jobs have you held? Those kind of questions you typically get asked. And then the request for documents. And that is basically any type of documents you may have that could be important. Medical records you may have. Sometimes your tax returns they do want to see, or your earnings stubs at least. It's usually pretty boilerplate type stuff that you see again and again in all cases. This is the first moment that you're really going to be involved in your case. This is what is going to be sent to you. And we'll go through this again. First thing that you really get involved with are these interrogatories and requests for documents. You will typically draft the answers and we finalize them with you in our office here. You don't have to physically come to our office, but we will get with you on the phone. Our office does, and we go over the answers. We make sure we understand everything. We look at all that, put it into a good final form for you before we send it off to the company's lawyer. Typically, as I described earlier, it's an interview on paper of about 15 to 20 questions. Not real invasive. Usually it's a lot of background on who are you, where you're from, give us your background, where you worked, how much have you made. If you've had medical problems in the past, what have they really been? A little description of each of those, that type of stuff. And they do generally want to know what happened in your injury, what caused it. Sometimes I'll ask, who do you think is at fault? And generally we'll work with you on those answers. At this stage, you generally do not have to give long, detailed answers about all of that, and we typically do not for our clients. The next part after you answer these questions and the request for documents is your deposition, and this is generally going to be about 3, maybe 4 months after your suit is filed. In your deposition, you are definitely prepared ahead of time. We absolutely sit with our clients. We go through 2 or 3 hours of preparation. We have a lot of videos we have them watch. This is a very good way to prepare them for their depositions. I have never in 23 years ever had a client say they did not feel fully prepared after their deposition. When we break and we sort of debrief on what happened and how they felt about it, they have never ever said they did not feel prepared enough. Typically they will say it is exactly what we covered beforehand when we were preparing them, and a lot of times frankly they're pretty amazed that some of the exact questions we had sort of predicted, and it's because this is the only type of case that our office handles, so we see these questions again and again. We're going to typically have the key documents for you to review at that time. We're going to usually go over any type of accident reports with you. We don't want there to be any big surprise in your deposition. And if there is a document or something you haven't seen before and it's shown to you, typically we'll take a break and let you look at it. We can even look at it with you. So it's not any kind of this gotcha by surprise deposition that you may see on TV. This is typically pretty boring. We're with you throughout the whole deposition. Some clients are surprised to hear that, but we don't just put you in a room and let them ask you questions. We actually sit there with you. You're going to have an attorney from our office sitting there with you during your whole deposition and making sure that the company lawyers don't get out of line. Typically it is about a 3-hour, maybe 4-hour experience. Some of them can be shorter than that, frankly. Sometimes if you're much, much younger and you don't have a lot of history, a lot of work history, there's not a lot of stuff to go through. They do run longer than that sometimes, especially if you're an older worker and you've had some injuries in the past, maybe even a few accidents, maybe even a claim or two. Typically that will take a while just to go through the material. It doesn't mean it's any worse of a deposition or worse of an experience. It just takes time to go through a longer life history than it does a shorter one. Witness depositions are generally the next item that get done. Again, what we're doing here is walking you through kind of the steps of the case as it progresses, so there's no surprises, so you understand what's going on. Witness depositions are taken after your deposition is given. These are typically your co-employees, We will usually at this point, for sure, we'll have a very good list of who we want to sit down with and ask them questions under oath. You can attend if you want to. You're definitely not required to. In our office, we really encourage our clients to attend if they can. The majority of them probably attend some of the depositions. A few of them don't attend a lot of them. It's entirely up to you. A lot of times it is better to have you sitting there during a witness deposition so you can eyeball them, you can hear what they're going to say. I like to say if they're going to say something untruthful, make them say it to your face. This is when we view this as getting to build your case. We get to go out and talk to the people that were there. We get to go through the history of how the job was done or should have been done, what caused you to get injured. This is us kind of building your case, is how I like to say it. Then we get into expert reports and expert depositions. Generally, these experts, there's going to be two or three types. There's medical experts and job experts. And those are what I would call your damage experts. If you remember those first few slides, we went through the categories on your case. First category is basically your damages. How badly hurt are you physically? What kind of medical limitations do you have? How much money are you going to lose? This is where these medical experts and job experts come in. So these fellows are really addressing that first category of what damage, if you will, what damage was caused to you in the accident. Like I said, they establish the pain and suffering. They go through the physical injury and the wage loss. The next type of expert here is the type that addressed the second category that we went through. If you remember, the second category was what happened, why did it happen, and who's at fault. This is where the liability experts get involved. Typically there's one, sometimes as many as two or three in each case, and these are individuals who have worked on tugboats or oil rigs. Sometimes they're crane experts, sometimes they're rigging experts. They can be naval architects a lot of times if there's some sort of defect with the ship or with the rig that didn't make it safe, that made it unsafe. Anyway, so you have your medical and job experts, and then you have your liability experts. Liability experts establishing fault. Next item here, and again, just to recap real fast, as we've gone through it, you file the paperwork in court, you've answered the questions on paper, you then give a deposition. We then take witness depositions. You can attend those. We encourage you to. The next step in your case is getting the experts lined up, figuring out how much damage, how big is that big ball of damage that we're arguing about that you've suffered. And then finally, when you get done with all that, it's time usually to sit down and start talking about resolution, settlement efforts. There's generally three main ways you can do this. And again, some of this is basic. Some of our clients appreciate knowing all this. Other clients just say, get me to the end, and I trust you guys and y'all guide me. But this is generally how it breaks down if you really look at it. There's three main ways you can talk resolution or settlement. First one are informal talks. This is basically just myself as your attorney calling up the other side saying, this is the type of money we believe you are due. We think that you should be compensated this much money for what you went through. And then the other attorneys may get back with us and give us a response or an offer to that. A lot of times it's back and forth that way. That would be kind of the informal talks that can occur. Another method is mediation. This is number 2, and this has become a lot more popular in the last 10 to 15 years, certainly. And frankly, we mediate the vast majority of our cases. This is when a separate day is set aside. You attend it. We will be there with you. The other attorney attends it, and usually his insurance company client or a representative from the company will attend it. And the whole point is to go back and forth through a mediator, which is a third-person attorney that's hired. They're neutral. They don't necessarily pull for our side of the case. They don't necessarily pull for the other side of the case. They try to kind of come in objectively and look at the both sides and see if they can get us together with an agreement. That's a mediation. Those are usually they're very helpful. Sometimes they do not work that day, but you can continue talks after the mediation, which can be very productive. It's definitely a good exercise that we, again, like I said, in the vast majority of our cases, we do mediate them. Then the last method here is generally court settlement conferences. Federal court, where a lot of Jones Act and maritime cases are filed, is generally going to require at some point the court to step in and meet with the parties if the parties cannot resolve the case through their own talks or through a mediation. The court is not going to let a trial go forward without being satisfied that the parties have really made a good effort to try to resolve the case, and sometimes, unfortunately, you can't resolve it. Which brings us to a trial. If, for whatever reason, your case is not able to be resolved, then ultimately the last step in the case is trial. I will say a few things at the beginning here. Trials are very, very rare. They're extremely rare. 99.99% of the time, settlement offers are made in cases. Frankly, in 23 years, more than 23 years of doing this, I don't recall a case where an offer has not been made. We have certainly tried a lot of cases. We've tried many cases, and that's because the offers have not been fair in our view or in our client's view. But clients will often ask me, are they going to make offers? Am I going to have to go to court? And the answer is they'll almost always make some sort of offer to you. Whether or not you believe it's fair and want to accept it is a different issue. Whether or not we believe it's fair and recommend it to you is another different issue. Ultimately, you're in control of your case if it does go to trial. You control if you choose to go to trial. Generally, if the offers are low, it may be something we don't recommend, but at some point you may decide that you want to accept the offer anyway. We have had some clients that do that, and that's certainly their right, and we're happy for them if they're happy at the end of the case. All we do is make our recommendations and give our best thoughts on where you are with the case and how to proceed. Last point here, only about 2 to 3% of cases ever go to trial. There's been a lot of studies on this, and this is probably true in our own practice. I mentioned earlier I typically try about a case, maybe 2, maybe 3 on a busy year, and that is out of our whole case load. So typically if you're trying about 2 to 3% of your cases that ultimately come through and get settled or get resolved one way or the other. So it will be rare if your case does go to trial. It's certainly something you can choose to do if the settlement offers are not fair in what you think they should be. Some final thoughts here before we close out this webinar. Hopefully it's been very helpful to you. Again, this is meant just as a big overview as to what steps happen. People will ask me, how does a case work? And sometimes I'll sketch out on paper and basically say these are the 7 or 8 stages of your case. This is what it's going to look like as you kind of go through it, so that there's no surprises and you know what's going on at every stage. Final thoughts here, and I tell this to prospective clients and to clients, you really only do 2 real things in your case is how I view it. And this is after more than 23 years of doing this. The first thing is you do have those interrogatories that you have to fill out. You have to draft those. You have to get some documents together. Typically, you really don't have to look for or go out and obtain documents you don't already have, so that's usually not a big issue. Usually the main thing you're doing is filling out questions, answers to questions, and you're sending them to us, which we draft. Those are your interrogatories. That's the first main thing you do in your case, if you will. And the second main thing that you do, or really the most active thing that you're going to do in your case, is give your deposition. And I typically tell our clients after the depositions that they give is that 99% of the case is done as far as their work on the case. They absolutely do come to the mediations. They will be involved in the settlement of their case, obviously, and you would too. But as far as any type of questioning by the other side or any type of, I don't know if you want to call it an adversarial thing, the only real times when you're getting asked questions and you're having to give answers are during your interrogatories and your deposition. The mediation, you don't do that. That's just you sitting, listening to their offers, deciding if it's fair or not. Same thing, even when you go to court with settlement conferences. Generally, it's not a stressful situation. Generally, you're getting offers to your case, and you decide whether you think they're fair or not. Last thing here, final thought, is that you control if you go to trial. And this, I mentioned this earlier, and this was kind of a last point here. Again, Clients will ask, are they going to make settlement offers? And I say 99.999% of the time you're going to get a settlement offer. Usually they're very good offers, and usually the cases settle. Ultimately, though, if the offer is not exactly where you want it to be, you control if you go to trial or not. So final thought here, go ahead and download our free worksheet, and we're going to have a little summary of these put together for you. This will give you some ideas and some reminders about this webinar. Hopefully you found it very, very helpful. Go ahead and call us if you have any questions at all. We're here to help injured maritime workers and injured seamen. Again, as I mentioned, we've been doing this for more than 23 years. This is the only type of case our office handles. Hopefully this has been helpful for you. Let me know if you have any questions at all. I'm attorney Tim Young, and our office here is called The Young Firm, and we have a national maritime law practice. Thank you.